An order is set aside, petition stands allowed. Petition is allowed.
May I please, your lordships. Item 30, my lord, of today's list, my lord. That case, my lord, I have already filed a additional affidavit, my lord. There was some mistake in my lord, miscase, my lord. This case was filed for restoration, my lord. And that I have already filed on 9th of, my lord, this month, February. But that additional affidavit is not placed on record, my lord. Matter is urgent as because, my lord, on 15, my lord, case speaks for, my lord, execution order, my lord. That's why, my lord, execution, my lord, for.
What do you want now?
I would like to take up the matter at 2 p.m. after, my lord, is calling the, my lord.
Item 30 additional.
Yes, my lord, my lord. Obliged, my lord.
May I please, lordship, with the consent of the other side, my lord, I beg to mention item number. We have filed an objection today, my lord. Let the matter come after 2 weeks, my lord. 23. I am for the appellant.
Oh?
For the appellant, in the miscase, I am the respondent.
The date accordingly.
Obliged.
By Mr. Lade
30?
3. Hearing
33. Matter before another bench.
May it please your lordship. I beg to mention item number 11, my lord. I beg to withdraw this appeal, my lord.
Item 11, you are Mr.
P. Sundi, my lord.
Mr. P. Sundi.
And item number 2 and 3. Swami is not appealing any. Last order dated 15/11 and 2021. Directed to remove his name. The file has been taken away by the.
Item 2 and 3. Appearing. Just 2 and 3, wait for a while, we'll call it.
May it please your lordship. With an apology, my lord. Item number 32. It's a second appeal matter of 2010. I am for the appellants and none appears for the respondents. Item 32. It's an appeal against concurrent judgment. Suit was dismissed. Appeal was dismissed. As against that, the second appeal is there. It's only on correction of name in the records and declaration of right title interest. But unfortunately, I could not trace the file. So I need to take certified copies of everything out. But services complete long back around 2013 for all. None have appeared also. So no difficulties, no question of stay because it's a concurrent judgment, my lord. So may I pay the matter comes up in 2 months' time. In the interregnum, I'll take out all copies, relevant copies.
Once for that.
No, not for that. Just to keep you on the safer side.
Say 1 month.
1 month.
Of 2010.
Yeah.
For the appellant submits that. And file has become untraced. Reconstruct the file after obtaining certified copies.
Lordship, I fixed it.
None appears for the respondents.
None appears. 19th of March. Grateful, my lord. Obliged.
27 and 28. The learned counsel for a respondent is presently out of station. And for the consent for others, the matter be listed on
27, 28. When?
Monday, 16th. Watch your class.
Yes, Your Lordship. This is a second PRS bill application, whether the allegation is against the provisions of the POCSO. So notice has to go on the respondent number 2, and my lord, the FIR is of page of 1825, page 15 in the vernacular. So the CD may be called for up-to-date CD, and the prime accused has been already granted bail. Yes, yes. Prime accused has been granted bail. There is an angle of love affair, and page 22, my lord will see there is a monetary transaction. Alleged incident is of 21,625, and on failure to pay the agreed amount that the accused boy would not keep any contact or communication with the girl.
Let us examine. Call for the CD on issue
My
notice.
lord, may it be on 18, my lord. It has to come from perpeta.
But Lordship, that notice has to, and it will take some.
My lord, in that case, can it be on 23rd? Obliged, my lord.
Sorry, in item number 3. Item 2, somebody else's name is reflected.
Another counsel, R. Katkatia is appearing, not appearing anymore. And along with my senior, I'm not appearing anymore.
None appears for the R. Katkotia had earlier appeared for the respondents number in the order that the file has been taken. None appears for the petitioners. The appeal is dismissed for
Yes, Your Lordship. Your Lordship, it is a fit case for mediation.
it case.
Yes, Your Lordship.
The other side.
Service is complete upon 1 and 3, and 2 has been struck off.
You're appearing for
I'm for the appellant, your lordship. The claimants.
counsel for the appellant submits that the mediation, but yes, for the एजेस है क्या? Hearing, I think.
For the insurance company.
Been struck off.
Who has been struck off, your lord?
2 has been struck off.
Yes, your lordship.
What about 1?
One, service is complete as per Lawazima order dated 21/4, 2017, your lordship.
P. The rest.
I am appearing for the.
For Mr.
Yes, sir.
So service on respondent number 1 is already complete. None has appeared. So we refer to mediation. I and agreed to by the. Shall we fix a date? Give a date. Matter again.
That's all.
Yes. Same. Date.
Nice, lordship. Mandela.
Yes, Mr. Lordship, matter may not be referred to mediation because it is an appeal against ex parte appointment.
This is Arunachal.
Small state of Arunachal Pradesh is the appellant. State of Arunachal Pradesh is the appellant.
Why is the matter here in the principal seat?
Guided by MSCT tribunal.
Otherwise, all have appeared.
Yes, yes.
It is already fixed for hearing.
It to be referred to.
All right.
Because they come for enhancement, in regard to the disability certificate, disability certificate assessed by the court also, and that he is unable to much of disability. So he has filed this case for hearing.
None appears for the appellant, learned
Case of 2016.
3. Wait for referral on
16.
I have the instruction to withdraw this.
where Mr.
Gupta, my lord.
of Mr. So-and-so.
One, my lord, there is a statutory deposit, my lord, of 5,000 before the registry. I may be allowed to withdraw that deposit.
How to withdraw the made before the registry.
Publish.
Yeah, please, your lordship. Referring this matter to mediation won't solve the problem. It will need adjudication. Because the learned tribunal below has held that there has been contributory negligence on the part of his driver, whereas there is no evidence to that effect. Lordship may kindly see the judgment.
You are appearing for
The appellant.
appellant is the claimant.
Yes.
What was the award?
Award is 50% of the awarded amount has been deducted on the ground of contributory negligence on the part
You
of
are
the
challenging that.
driver. Lordship?
You are challenging that aspect.
Yes.
Basically.
My appeal is restricted to that only. Otherwise, my appeal has been allowed.
I think they will be in a position to concede that in mediation.
Yes. That's why I say mediation is not possible. We fixed for hearing at an early date, Lordship.
I'm there. That's one number 1.
And
Number 2.
hearing.
12 months. 12 months. Much.
Obliged, Lord.
Perhaps this matter may not be settled through mediation, Lordship. This matter may not be settled through mediation. No point is involved, Lordship. The claim petition was filed under the MB Act, but the case was decided under the WC Act.
The total amount awarded.
Total amount awarded, Lordship, 6,19,390. Let the matter be listed for hearing. LCR has been received.
It was given under Employees Compensation Act
Lordship.
instead of Motor Vehicles Act.
Lordship.
What would be the difference according to you? How much more?
Much more. I have not calculated it, but much more. Let the matter be listed for hearing in the last week of March.
Wait for are involved. Learned counsel for the
Yes, Lordship.
Please, your lordship. Grant me 2 weeks time to establish and your lordship.
Lordship, maybe.
That also I'll have to see.
instructions from whom?
From the clients, your lordship. Because it's 23 matter, your lordship. He has not contacted us for the last 1 year, your lordship. He has not been in with us, he has not contacted with us for the last 1 year, your lordship.
He will get a notice from the mediation center. If he doesn't come, who will learned counsel for the perusal. Please.
Pleasure, lordship.
Please, your lordship, we need to take fresh steps because the other side is not present.
You last take steps. Years ago itself, that was there. Justice service.
Yes, and we did not file a affidavit. Kindly allow us to take respondent.
Justice service. Was allowed to be taken by order. Allowed release the matter.
Please, your lordship. Lordship, we did not take steps upon respondent. Grant us 1 week time. Steps on respond.
He is completed.
Yes, your lordship. And 2
Is struck off. One remains.
then 1, your lordship. The payment. Otherwise, your lordship, Mr. S.K. Talukdar appeared on behalf of condonation of delay.
So we are still stuck with the condonation of delay.
Your lordship, that has been disposed of.
This has been disposed of. Is available, then service is complete if he is hearing.
Yes, your
This
lordship,
has
but
been
his
shown.
name is not been reflected in the cause list. We'll try to contact him if appears for respondent number 1.
Learned counsel. One is yet to be served.
Yes, sir.
Okay, although Mr. S.K. Talukdar had an appearance for the said rest. I for condonation. None appears. Name come, then he can appearing or not.
The petitioner is ready for mediation.
The respondent submits. Again on.
I'm from the appealant side. Lordship.
Therefore, the respondent when none learned counsel for the matter may be referred is for the matter again on next week or that they did it. None appears for either side. Matter is dismissed for non. None appears for the appellant on call as reflected in the order dated 9/2/26. The appellant is for non-prosecution.
Case diary was called for that.
The proceedings.
Six.
So what new?
Similarly situated co-accused has been granted.
Here is bail. You are not annexed.
Next lordship. Your lordship had granted the Koilan Patton.
Clearly situated. FIR named accused.
Particular petitioner also is
Yes.
As early lordship, he's apart from that lordship, otherwise the
lordship on previous occasion when he was granted interim protection, he had diligently complied to the bail condition.
granting interim protection bail petition because lordship driver I'm accused.
Driver was Utpal Das, lordship.
You are Dipendeka.
Yes, lordship.
Hand over the CD, we'll see.
The allegation is based on the co-accused statement, which is
No, lordship.
heavily
Admitted lordship.
what value does it create? Might have been under coercion. Lordship will, I had already placed Harisaran Kurmi's case, lordship.
Last lordship.
Boxing CBR, lordship.
Yes.
Boxing CBR's case, lordship. Secretary bail. Your lordship shall consider.
You're for?
Respondent number 1 and 2, Lordship. Filed their Wakaratnama way back in 2000.
as listed on set.
One and two, your lordship.
On Friday. Huh? Please.
Was there, which was allowed, and I have submitted the amended first title also.
At counsel for the appellant. The respondent number.
One.
Here is received.
My name may be reflect. Oscar Mile.
Of
Oscar. Right.
Right.
In Lordship, I missed, I was just. Come for mediation also, it may go for mediation also.
17. The respondent. Sir, Mr.
I'm R. Goswami, Lordship. I've been running from in several courts, so that's why I put on missed it.
But nobody is appearing for respondent.
Well,
17, you write. The appellant and submits that the matter may be referred to mediation. However, none appears for the respondent. The names of learned counsel. The respondents. Is the matter again on? Let's have it on Friday.
Friday also.
Right now, can they come? Come after some time, we can refer it today. It's
It may come on Friday again, Lordship. I'll inform them in the meantime. Obligation. But the similar thing has happened to item number 2 and 3, all mediation matters, Lordship. Go for mediation, under it may be given also.
I think the respondent counsel appeared and said he were appearing there.
Again, we fixed on 13th also while we did. Today is in fact,
Had earlier appeared for that they are no longer the matter again on Friday.
deeply obliged.
Yes,
Item 21. But in this matter, madam, we have to take fresh steps, madam. On respond number 1 and 2. Here we have taken steps, madam.
Submitted on the appellant that fresh steps have been taken on the respondent's number. These have also been issued by speed post as per office note at 2001. Service. List again on.
Highly obliged. Please, your lordship. We are supposed to take steps upon the respondents. However, inadvertently, steps could not paying for 1 week's time to take steps.
Earlier also it was dismissed for default.
Your lordship.
And
Then we
readmitted.
have filed a miss case.
Delay.
Yes, there's a delay. In the delay, we were supposed to take steps.
Yes, you are supposed to
Inadvertently-
take step pursuant to order dated 21/4/25. So a year has elapsed. This is a matter of 2013. Tell us why we should entertain.
Last chance,
Yeah.
last chance may be given. 3 days time may be kindly be given, your lordship.
Mr.
H. Burago, your lordship.
Abst.
Your lordship.
IA 3168. Legal as of appellate number 2.
In time.
Yes, Lordship. Details of the legal errors are in page number 6, Lordship.
Hmm? To fight for amended cost item.
IA 3201, that was in filing the substitution of respondent number, Lordship. In that notice was issued. This AD card has been received back, Lordship. IA 3201. Three point one to 3.5 AD card has been received back, Lord.
Heard learned counsel for the A 320. Cards have been back after service. One and two. All are served. The length of delay.
400 days, Lordship.
They're opposing.
Filed any objection?
Presenting respondent. Sufficient cause from referring the appeal. Highest and least.
Connected IA setting aside abatement and substitute 02 03, Lordship. Our internet.
203. Three, 2, 0. Substitution also, these are the same people who have been served but not appeared.
As of respondent number 3.
Here I go. The legal heirs of the said A, B, C, D, E. Three.
For setting aside abatement.
Was there. Think that the appeal has abated. And
Abandon caution, we filed setting aside abatement.
A has been heard for heirs of the deceased. Specific order of abatement. Present. Is the appeal for Was admitted already.
Admitted, there is order of
Appeal for hearing.
Obliged lordship.
Please, Lordship. After the death of the secretary of the respondent organization, we have filed this application for implement of the new secretary of the
Impleted now.
Lordship, that was informed by the learned counsel for the respondent, Lordship, on 22/7/2025 by their notice under order 22 rule 10A, Lordship. Accordingly, that was informed that the earlier after the death of the earlier secretary of the respondent organization, Sarbanjina Kandapan was appointed as the secretary, Lordship. That was informed on 22/7/2025, addressing to us, Lordship.
By the appointed Frank Baptist. To represent the second appeal. Did you file this application? Was it within? Limitation is prescribed?
No limitation is prescribed.
Order one rule attracted. Striking out and adding of parties is where the proper party has expired and then in his place another party is to be. Not a case of striking out or adding parties.
As because the respondent organization is there, Lordship. The respondent organization there, but representative has died, Lordship. Organization is arrayed as respondent number 1. Secretary was arrayed as respondent number.
The representative's name is to be changed.
Yes, Lordship.
Connected. List again.
Last part. Yes. Much service.
No served notices. I. বহুত কেইখন আছে।
Wait, please, my lord. So this appeal was otherwise admitted and the steps were also complete upon the respondents, my learned friend. One out of the four appellants, that is the appellant number one, had expired. Invite this interlocutory application when intimating that to the court. Her name may be struck off. The other legal heirs are already in the area of parties as appellant numbers 2, 3, and 4. Her son and daughters.
Otherwise, it's ready for hearing.
Ready for hearing, madam. Just the name of appellant number one may be struck out.
A3994. Learned counsel for the I has been referred. Taking out the deceased appellant number one. It
Deeply obliged, madam.
Please, your lordship, this present I is for the substitute death of the suit. Lordship, the petitioner expired on 26/10/2025. The detail of the legal heirs has been given in the page number 6 of my application.
aired on 2016. Legal heirs, namely Sri accordingly. Hearing.
Uh,
for admission.
Bless you.
None appears for the order of the Lawazima court. The said order that the respondent number one. Seven, 6, 20. The above it appear stroke. Is the connect. One, the IA is for what purpose? But for which respondent? But for respondent number? Government. So they have subsequently they have filed another application for condonation delay separately. IA 258 of 26. Six, 7. What we should do?
Lordship. Lordship, in case we are directed to take steps by Lawazima Court, Lordship, what has happened, Lordship? We have information that some of the respondents also expired, but we are not in contact with the appellant. Therefore, we couldn't confirm about the date of the respondents and numbers, and so therefore could not file any substitution petition. That I will take instruction whether the appellant is willing to pursue this matter or not, Lordship.
You are appearing for?
1, 2, 3, 6, 7, and 9. Jed Mukit or Jed Mukit.
You are supposed to take steps on the respondents.
5, 8.
5, 8, 15.
Yes, Lordship. I will take the steps.
You will take.
By tomorrow, Lordship.
Yes, 1 week's time to take instructions from the appellant. It doesn't pursue already, you don't have to take steps, but these days, mobile phone and everything, you don't need. Sir?
1, 2, 3, 7, and 9.
It is submitted by. And that respond it that the respondents may fired. Whether he desires matter. List the
पाँच हो गया।
for the
After getting the state, my lord, last 14 years, my lord.
respondents.
Right.
524. File fresh memo of party registry 306. The registry to make corrections. Update the same in the CIS. It appears that step was taken by learned counsel for and the is for non-prosecution.
I have filed substitution petition.
We passed some order in 40 already. Please, I think, yes. Presley filed delay condonation application separately.
Yes, Lordship. First of all, first I have filed one composite.
Yes, we have issued notice on this. Instead of none appears, you read.
Lordship, they are appearing.
Yeah.
Other respondent and
Nobody's name is shown. Is it shown? Instead of notice, you say for objection. Okay.
at 2 p.m. Lordship. Deeply applies, Lordship. Add to there is an hearing matter fees.
Take this up before that.
In this first appeal against order passed by the learned rejecting my prayer for injunction, Lord, and while issuing notice 14/6/2007 granted. Thereafter, Lordship, on 10/11/2025, when one died, but in the meantime, they themselves the trial court, Lordship. So I have filed one composite application, that is IA civil number 822, Lordship.
3822.
22, Lordship.
But subsequently, you filed another one for
Another
condonation of delay.
Two applications,
So
Lordship.
we deal with that first.
Lordship. In the condonation application is IA civil 258, Lordship. As the person died on Lordship 19/4/19. The legal heirs already implemented them in 11/11/2019 before trial court. But in filing the applications, there is a delay of 2462 days, Lordship.
Appearing. Pardon? No objection.
Government is there for respondent number 6, 7, Lordship, and 8.
For the 258. Appearing for the and 8. Zero 21 days. Preferring the submit. Para having various sufficient cause from IS10. Now 259.
9, setting aside.
Setting aside abatement. Okay. Abatement of connected FAO number 35 of 2000. Passed in the connect. Connected IA. 5.9.
5.9. Application under or
Yeah, but the contents are of delay continuation. There are 2, 3.
thereafter the prayer portion, Lordship. Set aside the abatement in respect to the respondent number. Set aside the abatement in the 4 last portion we have written. As such, these 2 appropriate set aside the abatement so occurred in filing the substitution.
In view of the above, the abatement appeal is also right. Substitution in this petition itself,
822.
so I stands disposed of accordingly. 3822.
The 3 I have mentioned. Son and daughter.
The legal heirs. And substituted by I is the matter again now.
Obliged.
Please, Lordship.
My lord, here I have filed an application for restoration of RSA for default. In that miss case, my lord, the provision of the application is wrongly inserted. And for that correction, I have filed the amendment petition 195 of 2026. It ought to be Order 41, Rule 19 in place of Order 9, Rule 9. It is wrongly typed in the miss case, my lord.
Third learned counsel for the decision application seeking amendment of some advertent mistakes in title page of MC number 2025. It is stated that the provision law has wrongly been mentioned as Order 9, Rule 19 CPC. Order 41, Rule C, read with Section 151 CPC. Accordingly, correction thereof is sought, having regard the title page of the MC number 5 stands correct. Instead of order 9, rule 19 of C appearing therein, the same shall be read as order 41, rule 9, read with section 150. C. The corrections be made accordingly.
My lord, correction may be made by the obliged. And list the IA accordingly, my lord. Date may be, my lord. As my lord, execution is going on. Obliged. Okay.
Second appeal. What photocopy? Whether photocopy is to be admitted. That is a substantial question of law.
That is substantial question. Learned courts below commit error in holding the 1 and 2 are inadmissible.
Exactly. That is
Although
exhibit
the-
1 and 2 are the photocopies of the certified copies, isn't
As
it?
per judgment, but I could not go through the lordship. Check whether
I have
it's a
gone through. They are the certified copies of the
photocopies of the
photocopies.
that I have not gone through.
So what law do you want to show us to show that photocopies are admissible?
Lordship, there was no objection by the defendants. Lordship. The time of admission of the
Simply marked as an exhibit. How can there be objection? Was it on affidavit or not?
at the time of adducing evidence, they are marked as exhibit.
Not those documents which are inherently inadmissible, despite the fact that there is no objection, court cannot take them into account. They are specifically barred by law. So that there are some documents which may be allowed to be exhibited if there is no objection.
Are claiming their right through inheritance, Lordship. So only exhibit 1 and are the owner of those properties.
That is why you should have produced the certified copies instead of the photocopies. There in this.
May I go to LCR, Lordship?
You can go through, but this is a matter of 2016. We are not adjourning it.
Some of the defendants are the subsequent purchasers without prayer for their cancellation of the sale deed in respect of same land. Partition should whether
That story will continue for another 10 years.
Lordship.
But
No,
I'm
Lordship.
not inclined
After
to.
appearing in this case, Lord, I have corrected the appeal memo, Lordship. The effects in the cost at filing IS, Lordship. So, Lord, argue the matter, Lordship. Only the thing is that just I am learned friend that whether the photocopies or certified copies, because in my I have not gone through the LCR, Lordship.
Both the learned courts below have, after perusal of the record, held that these are photocopies. And your ground of appeal is also, that is also admitted. But your only contention is that since there was no objection, they should have been accepted. What is the law on that? That this should be, photocopies can be accepted.
There are some citations I am relying on this point. When there is no objection raised by the other side, the exhibits may be accepted, Lordship.
What exhibits may be accepted?
One is from Tripura High Court and one is from Gauhati High Court, Lordship. Past their lordship that 2021 to paragraph 11 lordship, the purpose and subverse and fact, Mr. Counsel has submitted at the time of admission of
Which one? Which one are you reading?
Lordship Subhas Dev, paragraph 12.
It's completely different. Because the
Sale deed
actual
was-
sale deed that was exhibited. The only question there was whether the executor, scribe or attestor was required to be examined. Question of any photocopy or anything like that. It was primary evidence.
Order 13, Rule 3, Lordship. Section of irrelevant and inadmissible document. The court may at any stage of the suit reject any document which it considers irrelevant and otherwise inadmissible, according to the grounds of such rejection.
On provision.
Order 13, Rule 3, Lordship. Court can reject any irrelevant and inadmissible document.
Objection was not declared that their photocopy accepted in try to exhibit the objection by the defense. Lordship more cautious copies. There was no objection.
That case, you could have applied before the appellate court also. That court could also have admitted evidence. It's a continuation of the suit. So that contention also does not hold good.
Both the courts facts are little different in Shubhas Dev. Findings in para 28. Lordship. Objection as read counsel for the plaintiff not be considered to be but in my opinion doubt or suspicion regarding schedule A of that could have been raised at the plaintiff could have but since no objection was raised that would not have parties for rendering admitted the sale deed under the garb of sham transaction exhibit 6 series section 68 of the that if by law to be attested one attesting witness subject to the process therefore thereafter follows a an attesting witness of the execution of a document has been registered in unless its execution by the person whom it purports defendants in their describing the real fact of the case of the without any specific as to the sale deed at subpara A of para 15. Also, the defendant lied about the owner for 5 bighas of land, lordship. Entire suit of the plaintiff cannot
I've stated in my WL.
In fact, the document that the court refused to take into cognizance, your exhibit 1 and 2, even if the original was produced, that also does not show your title to the land.
Lordship, this is the Jamabandi and we are claiming by inheritance. So Jamabandi is the inherited property, Lordship.
What is the finding of the
First appellate,
court? First appeal with regard to your
first appellate court, page 49, Lordship. Point for determination was formulated. Point for determination number 1, whether the learned trial court had rightly decided the issue number 9, wherein it held that the plaintiffs have failed that they and the 12 have right, title, and interest of the learned counsel for the plaintiffs that the learned trial court had wrongly exhibit number 1 and 2 are not admissible. The learned counsel for the respondent further contended that learned trial court had erred in holding that they have righted. The learned counsel for the respondent I have perused the trial court has ten bigha, 1 katha, 17 less. Page 57. You're covered by Khatiyan number 186 and for 2 bigha, 1 katha, 16 less covered by Khatiyan number, and that they being the legal sheikhs are entitled to inherit the perusal of the impugned judgment. Further revealed, trial court had observed that the plaintiff had record any document to show that Kharia Sheikh was the owner of the above land. I have perused the record and it appears that the trial court had rightly held that the title of Kharia Sheikh. In fact, the perusal of Exhibit 1 copy of Jamabandi specific originally belonged to one Hussein Ali Kabiraz, and thereafter the names Ayub Ali, Fazar Ali, Azad Ali, Mojad Ali, and Pan Bewa was mutated.
That is exactly what I am saying. You are nowhere there in the picture.
Lordship, they are the plaintiffs, Lordship. Azad Ali is pro forma defendant, Lordship.
Where is the name of Kharia Sheikh in that copy of the Jamabandi? The above exhibit does not show that the aforesaid land was recorded in the name of Kharia Sheikh at any point of time. So even if that was the exhibit was accepted, what would it prove?
Kharia Sheikh was original owner, so names were recorded. At the land are already made government khas by the government.
No, are these the legal heirs? Surat Ali, Tayyab, Yusuf?
Yes, Lordship. They are the legal heirs of Kharia Sheikh. Piaru Sheikh is the son of Kharia Sheikh and they are the son of Piaru Sheikh, Lordship.
No, Jamabandi would have mentioned from where it has come. How they inherited that land.
Petition order does not.
That case, Lordship, that principle will be applicable if there is a sale deed in there, Lordship, and if I am claiming my right title on the basis will or give deed, then this principle right title interest. But here in this case, they are claiming through inheritance. So inherited person claims right title through inheritance. They will base their claim only on the basis of only in the revenue records their name would have been after the death of their. The above exhibit 1 does not show that the aforesaid land was recorded in the name of at any point.
Oh, if you are the legal heirs of Kharia Sheikh, you would inherit from Kharia Sheikh only, not from Hussein Ali.
Kharia Sheikh
Who
son
is
is
Hussein Ali
Piaru Sheikh.
Kabiraz?
Kharia Sheikh son is Piaru Sheikh, Lordship.
No, who is there? Originally belonged to Hussein Ali Kabiraz. How do you get over that? Who is that? Kabiraz. If you inherit from Kharia Sheikh, then that would original owner would have been mentioned as
Contention of the
that
plaintiff.
person.
There is a contention of the.
That is what you have to prove.
Further pleaded that food.
If you want to say the land did not belong to Hussein Ali, it belonged to Kharia Sheikh, from whom the plaintiffs have inherited, then in that regard you have to give different proof. Otherwise, this Jamabandi will stand even if accepted. I did not challenge that mutation.
As settlement of has been mutated. Here, mutation has not been from that person purchased the land, the defendant subsequently, without the prayer for declaration that their mutation was illegal and our cancellation of subsequent sale leave. How the partition suit? Because they have to prove their right title interest first. But we have denied their ownership.
That out to some other persons without.
Why not?
As I am able to prove that defendants have no right, Lordship.
As the sale deed is not set aside, that will stand on a higher footing. How will it hold?
The plaintiff able to prove
You have to
case,
prove your ownership.
Lordship.
Defendants are not there to prove their ownership.
Able to prove that I am the owner of the property, then it is right that defendants have. They do not have any owner. Cannot sell the suit third parties, Lordship.
But how have you proved your ownership?
For that only.
At their ownership, sir. Burden is upon them, the ownership.
The courts held that there is a no prayer for. Shares only they are claiming and confirm. They are occupying the. Their prayer is to partition of the suit land. The legal heirs of Khari. Their share and defendant. Heirs of Kharia Sheikh. Only defendant number 1 is the brother of one of the wife of the one of. The
Question will come later on, only after you establish your ownership.
And moreover, Lordship, the first appellate court decision, your Lordship, and only while formulating the. Only one point was discussed, and thereafter, Lordship, no. Facts and law, Lordship. All the issues, Lordship. And this the duty of the first appellate to findings on each or the point which were formulated. Only one point was formulated and decided, and thereafter your Lordship will find
If the appellate court failed to exercise jurisdiction, then it would have been a matter of a civil revision.
Lordship,
But here we are only on a substantial question of law. We cannot travel there beyond that.
The concurrent findings.
Even if concurrent finding, Lordship, it is the duty of the first appellate court to decide each and every point. It is the mandatory requirement of Order 41, Rule 30.
perversity.
Paragraph 18, your lordship will find the appellant had not challenged the decision of the learned trial court in the issue number 1345. And I do not find any infirmity in the decision above issues, only this.
They're not going to travel there now. That is not a substantial question of law formulated now.
Perversity in the judgment, lordship. Right, jurisdiction
This is not a civil revision.
at the time of hearing also, lordship. First appellate court. Appellants have not challenged the other issues, lordship. Grounds they have taken. Paragraph 8. That the learned lower trial court has erred in law and in facts in deciding the suit. So entire judgment was under challenge. That the court below failed to appreciate the evidence on record in it.
And no other ground need to be stated if that line is sufficient.
And that the court below failed to appreciate the evidence on record in its proper perspective. That the learned trial court traveled beyond the pleading parties. That the learned trial court had not considered. That the learned trial court ought to have decreed. Entire judgment was put to by the first appellate. That point was but lordship, there is authority given to the any other substantial question of law at the time of hearing. 5 of the CPC High Court to formulate hearing also, lordship. On that point, I am relying the second judgment. Subhash Chandra Ranu Chaudhary versus Subhash Chandra Das, lordship. I have already handed over. Paragraph 5, lordship. Paragraph 6, lordship. That is.
Just a moment. Which point was not considered according to you by the appellate court?
Appellate court, lordship, only December 9, lordship. While formulating the point, only one point was formulated. I'm not on that, lordship, and even point the first but lordship, it is the first appellate court to and its independent finding has to be given order 41 rule 31. While deciding the point, page 50, a trial court had rightly decided the issue number 9, wherein it held that the plaintiffs have failed to prove that they defendant number 12 have right title and interest for the suit length. So only this was decided while deciding the point number 1. And later on in paragraph 18, your lordship will 61. First appellate court held that the appellant had not challenged the decision on a trial court in the issue
We have
number.
formulated the grounds of appeal 1, 2, 3, 4, 5. So why is the learned trial court required to travel beyond that?
I have challenged the entire trial court.
Oh, these are the grounds you have challenged.
Grounds?
5 grounds.
Yes, lordship.
So which is not covered by this point for determination?
Entire judgment was put
Don't keep
Every
saying that
issue-
entire judgment was challenged. Of course, the judgment was challenged, but what are your grounds of appeal that you have stated in your appeal memo?
That the court below failed to appreciate the evidence on record in its proper perspective. So all the evidences are,
Page 56,
yes, Lordship.
heard in law and facts, failed to appreciate evidence, travel beyond pleadings, not considered documentary evidence, ought to have decreed the suit. So which part is not covered by decision on issue number 9? It has considered all the facts and the law.
Only one issue was decided, but the other.
No, issue may be one, formulated as one, but not, it covers the entire gamut.
Lordship, there are some other issues also.
Saying that are in law and facts, why should it be decided separately? When the law and facts are discussed in the
There-
issue.
Some issues formulated by the learned trial court, that is page 55, Lordship. There were 10 issues.
10 issues, but you gave 5 grounds in the memo of appeal.
Yes, Lordship.
Then
Rounds 5, Lordship, I am challenging the entire judgment
no, that is
covering
not
all
the
the
law.
issues, Lordship.
Appellate court is to consider the grounds on which you have challenged. If you have not included the others, then why should the appellate court travel there?
I have covered the entire judgment, Lordship. Not specific, otherwise there was no challenge issue, Lordship. But the first appellate court held that there was no challenge from the appellants in where from the learned first appellate court get that finding that we have not challenged those
On
issues.
the grounds, you have not included them in your grounds of appeal. No, you have not put the entire, you have only challenged it on 5 grounds. Not the entire grounds.
Grounds we have said that the trial court travel on the pleadings of the parties.
That is the difficulty when grounds are taken so lightly in the memo of appeal.
The first appellate court or findings in each 7 issues. Paid for non-gender, misgender of necessary parties, there was no finding by the learned first. Whether the suit is barred by limitation, there was no finding. Whether the suit is barred by the law of estoppel waiver, finding. Whether the suit is read by section 10 and 11 of CP, finding, Lordship.
Not challenge that on those issues.
All the issues, Lordship, their favor. Part by section 10 and 11, it was affirmed in their favor in the trial court. Only thing is that they could not prove their ownership by exhibit 1 and 2. That is the learned first appellate court has discussed one point of determination. Whether the suit is maintainable from in their favor.
You are referring to order 41? Yes. Judgment of the appellate court shall be in writing. Shall state the points for determination.
Yes, Lord.
Stated the point for determination, which according to him requires determination. Yes.
Other issue, Lordship, the learned trial court in issue number 2.
Where does it say it has to cover all the issues framed by the learned trial court? Yes, that was the only relevant issue. All other issues were decided in your favor.
Number 2 by the learned trial court, page 30. Hence, the issue is decided accordingly against. Kindly see this. there is any cause of action for this case 37, file the present suit for the defendants, on the other hand, while denying their bona fide purchase, the defendants also did the alleged case of gift, further denied further the case of disposition of the plaintiffs. The rival claims and but as discussed and decided in issue number decided accordingly against the plaintiff. Regarding non-joinder issue number 3, that was parties. It was held by the number 4 is that lordship in issue is decided accordingly against the plaintiff. 4 is that lordship whether the suit is barred by limitation. That issue was also decided. There is no discussion by the learned trial court also in issue number. Basing on the issue number 2 findings, the learned trial court held that at the present issue. There was no proper discussions by all the issues, lordship. Only issue number 9 was decided by the learned first trial court, lordship. Adjudicator point was raised by the defendant. That issue was decided in favor of the
6 is in your favor. One moment.
Under order 41, rule 31, the court is bound to all the issues. It has stated the judgment should be in writing, the points for determination, the decision thereof, the result for already.
issue 1. Is 39. Trial court. For favor. That there is any cause of action that is there is no discussion. Whether the suit is bad for non-gender. This is in our favor by the page 38. Against us by the five was not pressed. There is no barred by the law of aspect. Issue was not pressed at the time of argument. So the 5 we can.
Where is issue number 7? What is issue number 7?
Jurisdiction try the suit.
That is in your favor.
That is. number 9.
So it must be presumed it is in your favor if there is no, there it is jurisdiction.
Page 36, Lordship.
Page 36, issue number 7.
And page 30.
Oh, it starts at
last
page
line.
35 last.
Yes,
Okay,
last
yeah.
line, issue number 7. Discussions in
So all except 2 and 4. 2 and 2 is the main root of the matter. 4 is just a consequence. Yes.
the plaintiff findings of the two, and even on a trial court has not discussed any, just given a finding that I'm basing on both the issues were decided against the plaintiff, and there was even not first appellate court on the issues. And it says that, Lordship, there was no challenge. Oh,
No, suppose this could have been worded better in view of decision of issue number 9. Plaintiffs have failed to prove cause of action. Suppose you have the cause of action, even then you may lose. That is decided in issue number 9. So what difference does it make if it is decided by the appellate court in your favor that you have a cause of action? Cause of action may be there. That doesn't mean case is proved.
through PW3 completely handed over to counsel of the defendants, Lordship. They in admission of the documents, Lordship.
Yes, that part you have already argued. Yes. Anything else?
Oh, Lordship, this is my
Respondent, anything to submit?
When tendered in evidence and it is admissible in evidence, printing Lordship can be part as a part of the record. The original or the certified copies, 1 and 2 only being the I'd like to submit a judgment of the Honorable Supreme Court basis, Lordship.
Suppose an electronic document without a certificate under section 65B gets admitted in evidence. Can the court consider it at the time of judgment? No, it is expressly barred. So,
There are 19 and
merely without, if it is without objection.
there are 19 and 23, Lordship. First appellate court.
that exhibit 1 and 2 was by adducing the evidence the Lot Mondal, and he প্ৰপত্ৰ 1 গাঁৱৰ জমাবন্দীৰ নকল ফটোকপি, কিন্তু ইয়াত টেপু আৰু নৈমুদ নাই। বাকী একে গাঁৱৰে 114 নম্বৰ পট্টা পিয়াৰু শেখ, পিতা ফৰিকা শেখ, টেপু।
Whatever Latmondal has deposed is on the basis of that photocopy. He is not carrying the contents in his head from his office. So what is the value of his
He proved
deposition?
that this is, though it is a
If he says from official record, that is a different matter. He is speaking from the photocopy itself.
has bring and map along with him.
And why not exhibit them?
No, it is the duty of the W to prove the original with the exhibit, Lordship. Per his
Who
statement,
took his evidence?
as per his evidence, Lordship, আদালতৰ পৰা সমন পাই তলব কৰা মতে চিটা জমাবন্দী ও map লৈ আহিছো. So he proved the photocopies with his.
You led the examination in chief. You ought to have got it exhibited then.
Have exhibited, Lordship, by coming from the office. He's an official witness, Lordship.
Where is that? That is not on record. If he had brought the original documents and they were exhibited, then then there would have been a stamp compared with the original. If the court allowed the photocopy to be kept.
Statements are there, Lordship. আদালতৰ পৰা সমন পাই তলব কৰা মতে চিটা জমাবন্দী ও মেপ লৈ আহিছো. His statement, ধৰ্মশালা চতুৰ্থ খণ্ডৰ 186 নম্বৰ পট্টা মূলতে হুছেইন আলী কবিৰাজৰ নামত আছিল. হুছেইন আলীৰ নাম কৰ্তন কৰি সুৰত আলী, ইউসুফ আলী, আয়ুব আলী, ফজৰ আলী, আজাদ আলী পিতা পিয়াৰী শেখ আৰু Silvan Bewa, George Mita Piari Sheikh. So these are the legal heirs of Piaru Sheikh, and Piaru Sheikh is the legal heir of Kharia Sheikh. So, নামে নামজারি হয় LS 906-7172 নম্বর গুছৰ মতে. I was, Lordship, arguing a fact that it was made government. Then after revenue order, the lands were purchased by this Hussein Ali in auction sale. Thereafter, the revenue board passed an order in favor of the plaintiff's father. Then subsequently, the lands were again mutated in the name of the Piaru Sheikh's legal heirs, Lordship. LS 906-7172 নম্বৰ গুছৰ মতে এই সমনৰ নাম কৰ্তন কৰি টেপু বেৱা, জৰ্জে ফুল শেখ আৰু নঈমুদ্দিন শেখৰ নামে নামজাৰি হয়. এই পট্টাত মাটি হ'ল 10 বিঘা 1 কাঠা 17 লেচা. প্ৰপত্ৰ 1 জৰীপ হোৱা গাঁৱৰ জমাবন্দীৰ ফটোকপি, কিন্তু ইয়াত টেপু ও নঈমুদ্দিন নাই. বাকী কেটাগৰীৰ হুবহু মিল আছে. একে গাঁৱৰে 114 নম্বৰ পট্টা পিয়াৰু শেখ, পিতা খৰিকা শেখ, টেপু বেৱা ও ফুল গণি শেখৰ নামত আছে. মাটি 2 বিঘা 1 কাঠা 16 লেচা আছে. প্ৰপত্ৰ 114 নম্বৰ পট্টাৰ চাৰ্টিফাইড কপিৰ ফটোকপি বহীৰ লগত মিল আছে. He proved the exhibits, Lordship. 186 নম্বৰ খতিয়ানৰ 89 নম্বৰ পট্টা ৰূপান্তৰিত হৈছে. পট্টাদাৰ হুছেইন আলী পূৰ্বৰ পৰাই পট্টাদাৰ হিচাপে থকাটো দেখা যায়. LS কেছ নাম্বাৰ 906-7172 আৰু 9692 ইংৰাজীৰ হুছেইন আলীৰ নাম কৰ্তন হৈ 6জন পট্টাদাৰৰ নাম উঠে. ৰেভিনিউ বৰ্ডৰ আৰু ASৰ আদেশৰ 10-8-93 নম্বৰ হুকুম মতে আন 6জন পট্টাদাৰৰ নাম কৰ্তন কৰি টেপু আৰু নঈমুদ্দিনৰ নাম উঠে. ইয়ান বহি অনা নাই, DC অফিচত থাকে. কেছৰ ৰায় অনুযায়ী ৰেকৰ্ড কাৰেকশ্যন কৰা হয়. এই 10 বিঘা জমিৰ মাজত প্ৰজাতি জমি থকাৰ কথা নথিত উল্লেখ নাই. মই জমাবন্দী 187 নম্বৰ ৰায়ত আছে বুলি উল্লেখ নাই. এই জমাবন্দী আছে, খতিয়ান চালে গম পোৱা যায়. মই অনা জমাবন্দীত 1996 চনলৈ ৰেকৰ্ড কাৰেকশ্যন কৰা আছে. 1996 চনৰ পাছত যদি কাৰেকশ্যন হৈছে, ৰেকৰ্ডত সেই কথা উল্লেখ নাই. ডাগৰ কোন দখল কৰি আছে মই ক'ব নোৱাৰো. চিটা বহীত এই কথা পোৱা নাযায়. 114 নম্বৰ পট্টাৰ দাগত মুঠ 2 বিঘা 1 কাঠা 14 লেচা জমি আছে. পট্টাদাৰ বহি আছে নে মৰিছে, বাচি আছে নে মৰিছে আৰু পট্টাদাৰ থাকিলে ৱাৰিছৰ নাম কিমান দিনৰ ভিতৰত উঠাব লাগে নেজানো. মই অনা ৰেকৰ্ড আপ টু ডেট নহয়. 1993 ৰেকৰ্ডেজ এতিয়াও আছে, কাৰণে কোনো চাৰ্টিফিকেট নাই. ব্যক্তিগত নলেজ জমি সম্পৰ্ক নাই. প্ৰপত্ৰ 1-14-99 ইংৰাজীত লোৱা ফটোকপি. প্ৰপত্ৰ 2 93 তারিখে লোৱা কপি প্ৰপত্ৰত টেপু বেৱাৰ সংশোধনী নাই. Witness came and proved those documents. How their name entered in the document. There was a LS case and corrected. Yaru Sheikh is the son of Lordship Kariya Sheikh, and Kariya Sheikh was the owner for due to non-payment of revenue that was. So that was challenged by the Kariya Sheikh and passed order in favor of them. Thereafter, when the government lands were purchased by Hussain and Kabiras, those were corrected in the name of facts were not considered. Yes, Lordship, if the facts by both the courts can be a substantial. The material evidences and pleadings were not considered by appreciate perversely those that can be a substantial. Where I am not on that, I am on pleadings and evidences were not properly discussed. And it is the duty of the trial court first to discuss each and every pleading and evidence. From the judgment of the learned trial court, your Lordship has only 2-3 lines there, the issues that was decided, Lordship. In fact, this is a clear case of remand. In the issues were not properly discussed by the first trial court. First appellate court has not also discussed the issue, all the issues independently. So this clear case of remand, Lordship. Kindly see page 20, last 2-3 lines. Real facts of the page 18 is the written statement by defendants and their pleadings in paragraph 15, page 20, last 2-3 lines. Their contention is that there are some purchasers who are also bona fide purchaser in possession parties to the suit. Thereafter, the plaintiffs have got no possession over the entire suit land except over an area of measuring 5 bighas. So there is a clear admission by the defense. So the entire suit of the plaintiff, trial court as well as that is also a perverse. There are cases that, Lordship, the land records still stands in the name of defendant, page 20, and late Tepo Bewa. These defendants and others who are bona fide are in exclusive use. Now my learned friend has just argued that basis of title, Lordship. But here it is the case of the defendants that their name is already entered in the Jamabandi, so they are the owner of the suit property. But recording of name only of one co-pattadar, except the other co-pattadars, does not that the other co-pattadars are not owner of the suit property. By inheritance, there may be 6-7, but the Jamabandi may. There are several instances here, Lordship. Eldest son's name already recorded in the revenue, the others were not recorded, Lordship. That does not mean that the other sons have no right title interest of from their father, Lordship. Lordship, they have a written statement denied the paragraph 4, Lordship. From the started that page 19, paragraph 12, that the contents of para 5 and 6 of the From there, their denial, Lordship. Before that, there was no denial. Para 1 to 4 of the plain, they have already admitted, Lordship. On the admitted facts need not to be proved. They have already admitted that we have possession 5 bighas of land. Paragraph 1, 2, 3, 4. Already they have admitted. There was no denial. There should be a specific denial. There was no denial by the defendants in that part from paragraph 1 to 4 already admitted. When there is no specific right that those facts, the proof that Kharia is the owner of the property does not require to prove by the plaintiff's, Lordship. It is already admitted by them. Only on the basis of that Jamabandi are the photocopies. On that ground, my right title was negated by the trial court and the first appellate, being the co-pattadar of the same lands. Statement, they have stated in para 1 that the suit is not, then the suit is major. Para 3 that the suit is collusive, embrace, fabulous, filed by suppression of facts, that the suit is barred by the law of limitation. That part they have thereafter, Lordship, they will time of argument, and that was already held by both the court that they barred by res judicata. And they said that in para 6 that there is no cause of action of the suit and try the suit. That was also in our favor, Lordship. Then the suit being for partition of all the movable and immovable properties have not been included in, and not properties have not been included in the properly valued. So their case, they are impliedly admitting that this is for partition, but the plaintiffs had not included the entire properties of Kharia Sheikh. And very well from this paragraph that they are admitting this is a suit for partition, but the plaintiffs had not included the entire property of the Kharia. Thereafter, they started denying paragraph 5 to 6.
This is in paragraph 4.
Paragraph 4, we have shown how the properties are devolved upon all the legal heirs. Even, Lordship, the shares are already mentioned in
Paragraph 4 of WS,
paragraph,
where they have denied, where they have admitted, as you say.
Lordship, in paragraph 6 of page 19. In their written statements, page 19, they have stated this is a suit for partition of all the movable and immovable properties have not been included in, not properties have been included in the properly valued. So they are admitting this is a suit of partition.
Partial partition is not mentionable.
So they are admitting this is a suit of partition, and Kharia Sheikh is the owner of the properties, but Kharia Sheikh's entire properties were not mentioned in the plain. It is their contention. Impliedly, we can help from this paragraph that Kharia Sheikh is the owner of the properties, as they are not denying my para 1 to 4. Plain paragraph 1 to 4 is the ownership of the Kharia Sheikh. Have categorically stated how he became, how we are entitled, what is the share of the plaintiffs. Those were mentioned up to paragraph 4. Those were they have not. They are denying paragraph 5, where we have stated that Piaru, his mother Pulta, and sisters Tolo, Bushi, Alo, and Depri got 8 bigha 1 kata 3 lesas out of Kharia's property. So they are denying the entitlement of the plaintiffs over 8 bigha 1 kata 3 lesa. Pulta expired and her share devolved upon her children. Our mother's share devolved upon PRO, that was denied by them. PRO got 1/3 of 8 bigha 1 kata 3 lesa. her four sisters 1/6 of 8 bigha 1 katha. Thus PRO got 2 bigha 14 1/8 lessers and each of 1 bigha 1 katha 70/6 lessers. This part they have denied. Entitlement of the specific shares they are denying. We are claiming our share from PRO. Their admission one another part in paragraph 15 page that 5 bigha the plaintiff. That part is there, Lordship.
Yes.
So how the all the 6 persons entered in Jamabandi 1 and 2 that came out during the cross-examination due to non-payment of revenue lands were made khas and government khas land was purchased by those persons. But in the meantime, the original owner and accordingly revenue board ordered in our favor, then accordingly circular corrected the name of all the person, but they by that time PRO Sheikh died, so his legal heirs names were entered. Facts were not decided by the learned trial court as well as by the first appellate.
This cross up PW. Yes.
First appellate court. Photo original. The right title interest over the